Receiving a grand jury subpoena can be stressful and confusing, especially if you're not familiar with how criminal grand jury investigations work. When I was a federal prosecutor in the Manhattan U.S. Attorney's Office, I led hundreds of grand jury investigations and sent out thousands of grand jury subpoenas. Now I represent individuals in grand jury investigations and often advise them on the best way to respond to a grand jury subpoena. So today I'm going to explain the nature of a grand jury subpoena and what you should do when you get one. Many people who are not familiar with the grand jury process overestimate the significance of receiving a grand jury subpoena. It does not mean that a grand jury got together and decided to launch an investigation. Often what happens is just one federal prosecutor decides that they need to conduct an investigation and that there's good reason to do so. And that can be the result of an anonymous call. It even can be the result of reading an article in a newspaper. In fact, often grand jury investigations begin and end without the grand jury itself ever learning that an investigation took place. So you should just think of it as a tool that law enforcement uses primarily to obtain documents and sometimes to obtain witness testimony in front of the grand jury. I've received calls from a lot of clients who receive grand jury subpoenas and actually think they're going to be required to show up in person and testify. And that's hardly ever the case. But it's an understandable response to reading a grand jury subpoena for the first time. If you don't understand how to read a grand jury subpoena, you miss a lot of important facts that you can find out just from looking carefully at the subpoena itself. So today I'm going to walk you through an actual grand jury subpoena, which I have in my hand, and it should be displayed somewhere on the screen in front of you, and talk through some things that you can learn by carefully reading the subpoena. So starting at the top of the subpoena, you'll see it says United States District Court. That's important because it means it's a federal grand jury subpoena. That means a federal prosecutor likely initiated the investigation as opposed to a state prosecutor. And there's a number of important distinctions there. One is you just want to know who's conducting the investigation. And another is that it's much more likely that you'll end up appearing in person if you get a state grand jury subpoena than if you get a federal grand jury subpoena. Under that, you'll see it says District of, and then there's a state. And there's 94 different districts in the United States. And by looking at that entry, you'll know which of the districts in the United States is conducting the grand jury investigation. And that means a federal prosecutor sitting in a U.S. Attorney's office in that district signed this document and sent it out as part of an investigation. Underneath that, you'll see blacked out the to line, and that's the entity on whom the subpoena was served. And one thing you want to carefully look for there, especially if you're a corporate entity, is whether or not they correctly described the corporate entity. So I frequently represent financial institutions and fintech companies that have complex corporate structures, and often the subpoena is actually served on the wrong entity. You want to make note of that, and often you'll call back to the federal prosecutor and say, can you issue a new subpoena that correctly identifies our institution? To the right of that, you'll see it says subpoena to testify before grand jury. And that's because of the nature of the grand jury process. It's always phrased as testifying before the grand jury, even though it's rare for the witness to actually show up and testify. But right underneath that, you'll see subpoena for, and there's a box for person and a box for documents or objects. This clarifies that even though it says subpoena to testify, what they really want is the documents. They don't want a person to show up and testify. But because of the nature of the legal process, it's phrased as, and you see this right below, as a commandment to appear and testify. And it lists a place, here it's in Newark, New Jersey, a room, a specific grand jury room, and a date and time. And one important thing for you to know is if they're asking for documents, they rarely want you to show up in that grand jury room with the documents in hand. In fact, if you do that, often there won't be anybody there. So it's important to call the prosecutor or the agent that sent you the subpoena and clarify how they would like you to produce the documents. You'll see underneath that, it specifies a Schedule A. Schedule A, which we'll get to in a moment, actually lays out the various requests. So from the face of the document so far, you don't have any idea what it is that is actually being investigated. But when you look at the schedule, you'll get a lot more information on the categories of documents that they're requesting. Under that, it specifies the agent's name and the specific office that is requesting the documents. And it then says that the records should be provided in a computer-readable file format, preferably as a Microsoft Excel compatible file. And that's often the case. So when they're asking for documents in an electronic format, sometimes they want you to send a DVD or a CD that contains the information. Sometimes they want you to email them the information or upload it to a data room. And you want to get clarification on the nature of the production that they're expecting. Further down, you'll see that there's the name of the clerk. Usually these are just forms. They're not specifically signed by the clerk. Sometimes they are. But it's the federal prosecutor's signature that usually initiates the actual grand jury investigation request. And you'll see underneath the deputy's name, which is blacked out here, it then has the name, address, and phone number of the assistant U.S. attorney. And that's generally the person who you want to call. Sometimes it makes sense to call the federal prosecutor, who's the assistant U.S. attorney. Sometimes it makes sense to call the agent. You can call either of them and get clarification on what the nature of the production is that they want from you. So turning to the next page, this is where it clarifies Schedule A, and we've blacked out the entire thing, but this is the general format. There will be a schedule, and then they'll ask for specific categories of documents. And those really look like any other type of document requests, like all documents relating to a specific account number between a specific year and another year, something like that. And after that, you'll see that the request is for all forms of documents, including hard copy, emails, texts, letters, etc. And that's generally the way they phrase the request very broadly. But sometimes when you call them and ask for further clarification, they'll narrow the scope of the request. And that's an important thing to figure out right up front before you devote a lot of resources to collecting documents that they really don't want. So I hope that's helpful. That gives a sense of what you should look for when you first receive the subpoena. So if you get a grand jury subpoena, what should you do after you read it? Well, the first thing you want to do is make a determination of whether you think that you're the subject of the investigation. I frequently represent financial institutions who get grand jury subpoenas, and they're not a subject of the investigation. They're not a target. They just happen to be the custodian that is holding records that relate to the bank account of somebody who's an actual subject or target of the investigation. In other instances, the institution is itself the subject or target of the investigation, and that calls for a very different type of response. So if you think that you might be a subject of a criminal investigation, you want to right away reach out to counsel. If you have counsel in your company that is familiar with the grand jury process, you want to speak to them right away. If you don't, then you generally want to engage outside counsel to advise on how to respond to the grand jury investigation. Once you've spoken to counsel, another thing that you want to do right away is preserve the documents that are requested. One of the biggest mistakes that we see in criminal investigations is when somebody gets a grand jury subpoena and then intentionally destroys documents that are relevant to the investigation, or just out of negligence fails to preserve them. So some documents just get automatically deleted on a regular basis. Most companies have some document retention and document destruction process in place. Maybe they delete emails every 3 years. Maybe they delete emails when somebody leaves the company. But once you have received a subpoena, it's important that you not delete any documents that relate to that subpoena. Because even if you do that inadvertently, it can end up creating a potential for you being investigated for obstruction of justice. And both prosecutors and law enforcement agents will tend to infer that if you destroyed the documents, you may have been doing that because you did something wrong. So you don't want to do that. The next thing you want to do is reach out to the prosecutor. So you want to reach out to either the prosecutor or the law enforcement agent and just negotiate the scope of the subpoena. Generally, you're going to want to do that through counsel. through somebody who is familiar with the grand jury process, but sometimes it's not necessary. And you can just call and try to narrow the scope of the subpoena in terms of the time period of the documents, in terms of where the documents are stored. Often you want to get an extension of time to produce the documents. And there's a variety of different ways that you can really reduce the burden on your institution of responding to the subpoena. And often that's completely consistent with the goals of law enforcement who are conducting the investigation. The next thing you want to do is discuss with law enforcement your own potential liability. So if you can, you want to get clarification that you're not the subject or target of the investigation. If they say that you are the subject or target of the investigation, then again, you want to immediately be discussing that with counsel. In addition, if you think that there may have been some form of wrongdoing in your institution, separate and apart from responding to the grand jury subpoena, you generally want to investigate that. And you want to think about how to conduct that investigation in a way that protects your rights within the grand jury investigation. So learning that you're subject of a grand jury investigation is scary, and the implications can be complicated. But good news, I'm a lawyer. So if you have questions about how to respond to a grand jury investigation, give me a call. And if you want to learn more about responding to grand jury subpoenas and criminal investigations, check out my YouTube channel. I'm hoping to add more videos about those topics soon.